Welcome back to LAWSTACHE channel. My name is Anton Vialtsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to focus on the case that deals with confessions. And namely, we're going to focus on three issues. What it means to make a spontaneous statement, how intoxication is related to Miranda rights, and whether a drunk person can waive his Miranda rights, and finally, what it takes to unequivocally invoke your right to remain silent. Before I want to go on, I want to thank you for watching me on YouTube, subscribing, hitting that bell notification button, so next time I post, you'll be first to know. And if you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support my channel, consider going to LAWSTACHE.com and clicking under merch and checking out some of my products, including this Do Not Arrest This Person t-shirt. I have hats and other products. Thanks a lot for watching.
Quick message from LawStache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vialtsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawStache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LawStache YouTube page. That's LAWSTACHE.
Today we'll discuss a case that deals with confessions, and it's not going to take too much of our time because it runs through all the issues rather quickly. We're talking about United States versus Harris, where officers received a call from a hotel staff that there was an individual who refused to leave the property. When the officers arrived, they saw a door to a hotel room slightly open, and through that opening there was money and some white powder on the bed. Mr. Harris came up to the door. The officer briefly detained Mr. Harris and read him his Miranda warnings. Mr. Harris told the officer that he understood the warnings and was willing to talk to him, but he said that he had $50,000 to offer to the officers to let him go. He also mentioned that he was with the cartel and MS-13 and so on. The officers did not accept the bribe, and instead they sought consent from Mr. Harris to enter the room and search it. Mr. Harris consented to the search, which is something I always deal and talk about on this channel. Never consent to searches, but Mr. Harris did. The officers walked in and they found cash, drugs, guns, and drug paraphernalia. Mr. Harris was arrested and taken into custody, driven to jail. There, another officer approached Mr. Harris, read him his Miranda warnings. Once again, there was some back and forth whether Mr. Harris understood the warnings and wanted to answer questions. But eventually what happened is that the officer told Mr. Harris that he wanted to speak about a key that was found on Mr. Harris that belonged to a vehicle that was parked outside of the hotel, and that vehicle was stolen. Now, Mr. Harris refused to answer questions, but when the officer was walking out of the room, Mr. Harris told him that it was his vehicle and his keys. Now, we're in the appellate court level, and Mr. Harris argues that all of the statements that he made should have been suppressed at a lower court level because his waiver, his Miranda warning, and that waiver was not made voluntarily, knowingly, and intelligently in violation of his constitutional rights. So let's discuss the three issues I've mentioned earlier in order. First, the $50,000 and the fact that he's part of MS-13 on the cartel. The court said this is a spontaneous statement, not in response to interrogation. So remember, courts have repeatedly held that voluntary statements, not in response to interrogation, are admissible and are not barred with or without the giving of Miranda warnings. What does that mean? Simply said, the only time Miranda applies is that when you're in custody and being interrogated. Custody plus interrogation means Miranda. In this situation, the court says that Miranda simply didn't apply, whether Mr. Harris understood it, received it, or not, because what he said was a spontaneous statement. Nobody was questioning him at that time. Now let's move on to the second issue, intoxication. The court held that intoxication alone does not preclude a valid waiver. For example, in the United States versus Figueroa-Serrano, which is an 8th Circuit case from 2020, the court found there that a valid Miranda waiver when the suspect, after using marijuana, did not appear affected by intoxication and told the officers he understood his rights. So instead, the test is whether, considering the totality of circumstances, the mental impairment caused the defendant's will to be overborne. The district court found that Mr. Harris seemed alert, aware of his criminal liability, and making appropriate responses to questioning. The court also noted that Mr. Harris seemed coherent, and he never mentioned to the officers that he was intoxicated, whether using drugs or alcohol. The court also noted that Mr. Harris had an extensive criminal history, and thus he had experience with law enforcement. All of these factors weigh into the fact that in this situation, even if he was intoxicated, his will was not overborne. And finally, to the third issue, Mr. Harris contends that the statement that he made to the officer in jail about the key should have been suppressed because it was a statement made after he invoked his Miranda rights. But the court says that courts have repeatedly held that in order to invoke your right to remain silent, a suspect must unequivocally express his desire to remain silent. I will let you research this topic a little bit more and watch some of my videos on my channel about Miranda and your right to remain silent. There's cases all over the place, and it deals with a situation whether an individual can remain silent by remaining silent. And the answer is no. The suspect must make an expression unequivocally that he wants to remain silent. Thus, you must always tell the officer that, number one, you don't want to speak, you're not willing to answer questions, and number two, that you want a lawyer present. That stops the interrogation. Otherwise, the officer can continue asking you questions, and in this situation, there was some back and forth about the Miranda warnings, but at the end of the day, Mr. Harris told the officer about the key. And for these reasons, all of the statements that Mr. Harris made are in fact admissible against him in the court of law. If you enjoyed this video, please give it a thumbs up, subscribe to my channel, hit that bell notification button so next time I post, you'll be first to know. If you're listening to the podcast version of this recording, please give it a 5-star review rating. And finally, if you want to support my channel, consider going to lawstache.com/merch and checking out some of these incredible products, like the one that says "Do not arrest this person," this t-shirt, as well as my hats and some other things. Thanks for watching.